Hello. Yes, welcome to the final trial of the Proctor and Hobbs and University of Bradford Law School mock trial competition for 2022. We'll get underway very shortly. We'll allow our prosecution to introduce the facts of the case when we get started properly. Welcome to the University of Bradford in the City of Culture of 2025. We'll get started. This could be a good way to celebrate. Let's get through. So initially, I will swear in our defendant, and then the facts of the case will be discussed by our prosecution team. Okay, is Mr. Phil Mitchell in the court here, please, today?
Yeah.
Thank you, Mr. Mitchell. Yes, please just confirm your name and an address.
Phil Mitchell.
And an address, please.
22 Acacia Avenue, Bradford, BD1 WTF.
Thank you very much. You are here today charged with a homicide offence, that being unlawful and dangerous act.
Not absolute rubbish.
Manslaughter, if you allow me to finish, please. You will have your chance to speak when called. Thank you very much. Okay, so yes, and the facts are before us that on the 21st of March of 2021 that you, Phil Mitchell, did push a Mr. David Platt, with the result that Mr. Platt sustained bodily harm and as a result died of those injuries. How do you plead to this charge?
Not guilty.
Not guilty. Thank you very much. And if I could swear you in now, or if our clerk could swear you in.
Could remain standing, please, Phil Mitchell, and repeat after me. I do solemnly, sincerely and truly.
I do solemnly, sir, you have to say that again.
I do solemnly.
I do solemnly.
Sincerely.
Sincerely.
And truly.
And truly.
Declare and affirm.
Declare and affirm.
That the evidence.
That the evidence.
I shall give.
I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Right, you may be seated. Thank you.
Very good. Thank you. Yes, when you stand up, please give your full name for the court to our two counsel, and I will invite our prosecution to give an opening statement.
No, it's the court's prosecution, is it?
Yes.
It's the court's prosecution, our prosecution.
It's the state's prosecution, Mr. Mitchell. If there is...
Thank you for that, Your Honour.
Please.
Your Honour, members of the jury, I, Miss Melody Amadi, appear for the prosecution, while my learned friend, Miss Jennifer Hurst, appears for the defence. She, as you well know, will be defending Mr. Phil Mitchell. The summary of the case before Mr. Mitchell is charged with an offence of the Unlawful and Dangerous Act manslaughter, covered under Section 5 of the Offence Against Persons Act 1861. The summary of the case before you today is this. Mr. David Platt and the victim, Mr. David Platt, and the defendant, Mr. Phil Mitchell, were neighbours. They had argued on numerous occasions concerning Mr. Platt's noisy car, and on one occasion their argument had been so heated the police were called to diffuse the situation. This was in 2019. However, the incident central to the case today, which we have today, is that which took place last year. Late in the evening of March 21st, 2019, Mr. Mitchell confronted Mr. Platt. 2021, I may correct myself. Mr. Mitchell confronted Mr. Platt with a cricket bat, and during the confrontation had pushed Mr. Platt quite firmly, causing him to stumble, fall, and hit his head on a curb. Mr. Platt sustained a severe injury, a traumatic head injury, and needed attention, medical attention. Mr. Mitchell will testify today that he initially did not see that Mr. Platt had sustained an injury from the fall, due to the fact that it was dark. However, the victim's mother, Miss Sally Platt, who was awoken by the commotion, saw from her window that he had hit his head. She was the one who called for the ambulance and the police, and was the one who put the victim in a recovery position. She will testify that Mr. Mitchell did push David, causing him to sustain an injury, and it was as a result of that injury that he needed medical attention. You will also hear members of the jury from PC. Cotton, the police present at the evening. She will testify that David did, in fact, sustain an injury in the head. In regards to that evening, Mr. Platt was later taken to Albert Street Hospital, where he was being treated for his wounds for 2 weeks. He was making a full recovery, and his relationship with the defendant was also improving. However, the day before he was to be released, or the day he was to be released, the ceiling of the hospital ward in which the victim was staying in collapsed due to flooding. Mr. Platt was instantly killed. Members of the jury, the reason for my presence this moment is not to give you a detailed explanation of the laws regarding this case. Rather, it is to give you a summary or a snapshot of the main issues to consider. In regards to the offense of unlawful act manslaughter, one requires that the defendant has carried out an unlawful and dangerous act which led to the death of the victim. In regards to mens rea, or the mental state of the defendant, we must first satisfy that there was an intention of the base offense, which we see is an assault occasioning actual bodily harm, which derives its properties from battery. Ladies and gentlemen of the court, the area of contention for this case, however, is causation, whether the defendant did cause or has a clear link to the death of the victim. With the court, after you have heard all the evidence, and if you do believe beyond reasonable doubt that all these have been satisfied, we ask that you find the defendant guilty as charged. And this is my opening on behalf of the prosecution. With the court's permission, I would like to call the witness, PC. Cotton.
Yes, please. Thank you. PC. Cotton, are you in the court? Please come to the witness stand and be sworn in by the clerk. Thank you.
Please confirm your name.
PC. Cotton of the
And your-
Albert Police Station.
Right. And you, thank you. If you could repeat these words after me. I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence that I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
You may be seated.
Thank you.
Your witness.
Hello, PC. Cotton.
Hello.
PC. Cotton, are you the police officer who responded to the altercation between the two neighbors, Phil Mitchell and David Platt, on the 21st of March, 2021,
Yes. That's
Yes.
on the 21st of March, in the evening.
in the evening? Was this your first time being called to that address?
No.
No.
I think if my memory serves me right, sometimes in 2019, I think in October, I was called and I had to intervene between the two parties. That's the deceased now and then the accused person in this case.
What was your reason for being called to that address?
Okay, I think it was simply a case of two neighbors having a misunderstanding about Mr. Phil's noisy car. Yes, I think Mr. One of the parties has a noisy car. I can't remember who now because it's been a while I wrote the statement. But one of the parties has a noisy car, and then the other neighbor finds it very unpleasant, especially when it comes home at night.
Yes. Well, how heated was the argument? How heated was the altercation?
You mean?
Could avoid leading. Did the witness say heated or?
Oh,
Are we-
apologies, Your Honor.
If you could just allow the witness to answer the question.
Yes. Could you tell me what happened when you did go there?
On which occasion was it? Was it
2019?
Okay,
Yes.
in 2019 they had. It was more like an argument between the two of them about one person's car obstructing the other person, and I tried to, mitigate between the two of them. Although I made no arrest,
Yes.
so I just assumed that it was settled because I felt it was just a case of them, reaching a conclusion and living together peacefully. So there was no point making an arrest.
All right then. Going back to the evening of 21st March 2021, how dark was it when you arrived at the address?
Like I said, it's we do a lot of cases, so I may not be able to give you particular information or how dark it was when I got there, but I knew it was in the evening when I got that call.
All right then. Could you tell us what you saw when you arrived?
Okay, when I got there that day, I saw a man on the floor who was injured in the head, and I saw an ambulance, and then I saw about 5 persons there. The neighbor in question who had inflicted the injury, I think the deceased mother, that's Miss Sally, was also there, and then I think some other neighbors who probably heard the noise came there, but there were about 5 persons with an ambulance.
So you agree that it was David who was on the floor?
Yes, it was David who was on the floor.
All right then. His injuries that you saw, were there any lacerations, cuts, bruises?
Well, I'm not a medical doctor or medical personnel, but I know that he was severely injured for them to have called the ambulance. Yeah.
Would
He
you say
needed medical attention?
yes, an open cut or?
Well, I didn't particularly look at him, as it were, but I knew he was injured. He was hot. At least I could say that for sure, that he was hot.
All right then. Thank you. The end of my chief examination, Your Honor.
Okay, thank you. Would our defence like to cross-examine the witness?
Thank you, Your Honour.
Hello, PC. Cotton. Just to clarify a few points that you've just raised. When did you first meet Mr. Mitchell?
Okay, that was the first time I encountered them or had to talk to them was in October 2019.
And you met Mr. Platt at the same time?
Yes.
How would you describe the mood of Mr. Platt at the time, as well as the mood of Mr. Mitchell?
On which of the days?
In 2019.
Well, they were both angry, furious at each other, both not being pleased with the action of the other person, and
Mhm. Thank you. And were either of the parties known to you before that evening?
no.
No.
Before
And
2019?
Before 2019,
No.
yes. And have either parties been known to you since that evening, before the events that occurred on the 21st of March 2021?
No, I didn't have any need to
Okay.
interact with them until 21st of March, after October 2019.
Yeah. So between that time, there were no further issues?
No.
No.
Not, at least not that was reported.
That you were aware of?
Yes.
Thank you. And on the evening in 2019, you say there were no arrests made.
Yes, no arrest was made.
And can you explain the reasoning behind this?
Yes, as police officers, we have the right to also exercise our discretion. And I felt the case between the two parties was simply a misunderstanding that could be resolved with both parties sitting down, to reach amicable terms. So I just felt it wasn't necessary to make a molehill out of a small issue. So I didn't make an arrest.
Yes. And did you have any reason to suspect there would be any risk of violence following that evening?
Well, like I said, I didn't foresee it, because I just assumed that after they spoke, they had probably resolved, and
Yeah.
I didn't hear anything from them.
It was resolved. Thank you. So just to go over the events of the 21st of March 2021. How long did it take you to get to the scene?
Okay, I think it took me about 5 to 10 minutes. I just got the signal. I was about, I think, 5 minutes away. So I think with traffic and some other issues on the way, I got there in less than 10 minutes.
Okay. And in your witness statement, you say that the ambulance was already there when you arrived. Is
Yes,
this correct?
Yes.
So the ambulance got there promptly, you would say?
Mm-hmm.
Okay. And where was Mr. Platt when you got to the scene?
They were all there.
And he was receiving medical attention?
Yes. The
From the
paramedic, the
paramedics.
ambulance was there, so they were trying to administer first aid before, wheeling him into the ambulance.
Yes, of course. And you mentioned in your statement that you brought Mr. Mitchell into the station to give a formal statement.
Yes.
And is this a routine procedure?
Is it a?
A routine procedure? Would you normally take the witnesses in for questioning?
Yes, usually when an arrest is made, they have a right to. We usually tell them why. Usually when we arrest suspects or people who have committed an offence, we tell them why they've been arrested, and we give them the opportunity to make a statement.
Yes.
Which eventually, if properly followed, we bring it to the court to prove our case.
And how would you describe Mr. Mitchell's mood when you brought him in for questioning?
Well, he appeared sober, a little sober, but
Yeah.
the deed had been done.
Was he cooperative?
He didn't have a choice. He had to just cooperate
Okay.
because he was in our custody.
Yes. And did he appear remorseful?
Like I said, he appeared sober, but the deed had been done.
Yes, of course. Thank you very much. No further questions, Your Honour.
Thank you. Somebody, anything in re-examination?
Yes. With the permission of the court, I would like to re-examine the witness.
Please.
PC Cotton, I would like to ask to go back to the night 2019 October when you first interfered with the altercations. Was there any physical contact when you went there between both Mr. Platt and Mr. David?
Fighting?
No, it doesn't necessarily have to be fighting, but did they push each other, shove each other, touching?
Objection, Your Honour. Apologies. I believe that isn't a matter for re-examination.
Could you clarify exactly?
Her line of questioning has arisen out of another matter other than what was discussed in the original examination.
Okay, specifically, sorry, I was following a wider train of thought, but
Apologies.
what?
The question that she's asking has not arisen from the cross-examination. It is a new question.
Okay. Yeah, okay, from the cross-examination. Yeah, I was hoping that you would get to your wider point. Do you want to rephrase what you were saying? Yeah, you can't use the re-examination to ask questions that you intended to ask earlier on. It can only be things that stem from the questions that you were hearing. So, yeah, I agree to an extent. But would you like to rephrase it to try and get to the point that you wanted?
In 2021, when you did take the defendant in for the when you did take him in for an arrest, did you ask him if what he had done with the victim, if he had touched the victim or had any physical contact with the victim before he resulted to his injuries?
I didn't. Can you take that again?
Did you ask the defendant what had led to the victim's injury, seeing as you did make an arrest that evening?
No, it was in his statement. He made the statement that he actually pushed him, but he didn't think that it was going to be that bad.
Yes.
He actually admitted to have pushed him, you know.
He admitted to
yes.
you that he had pushed him?
Yes, and then the mother of the deceased was watching.
All right, then.
She was able to, that was more like corroborating.
All right, then. When you spoke to him, were you able to tell if he meant the pushing deliberately, if he had any thoughts behind the pushing?
Well, I think that's for the court to decide.
All right, then. Thank you, Your Honour.
Okay,
Nice one, Doc.
thank you.
Good to see you.
Okay, thank you very much. You may return. If you could remain calm, please, Mr. Mitchell, until we are.
Just wonder when somebody's going to talk about the hospital falling down.
Well, we'll get there. Don't you worry. It's your witness I understand. Okay. Yes. Would you like to call your second witness, please, Mrs. Madden?
Yes. With the permission of the court, I would like to call on the witness, Sally Platt.
Yes, please. Sally Platt. Are you here today? Thank you. If you could remain standing while you are sworn in.
And if you could confirm your full name to the court, please.
Sally Platt,
And your address, please.
54 Highwater Avenue.
Right, thank you. If you could repeat these words after me. I, Sally Platt,
I, Sally Platt,
do solemnly, sincerely,
do solemnly, sincerely,
and truly declare
and truly declare
and affirm
and affirm
that the evidence that I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. You may be seated. Your witness.
Hello, Sally. May I ask you the relationship you have with the defendant, Mr. Mitchell?
He's my neighbour.
He's your neighbor. Okay. Could you tell us what you saw on the evening of the 21st March 2021?
Yeah, so I remember it was my birthday on that day, and had been celebrating with some friends. I was getting ready to go to bed, and I heard a commotion outside. So I went to the window, and I saw Phil push my son David, and he fell onto the floor.
You saw him push your son?
Yeah.
All right, then. In regards to the way Mr. Mitchell pushed David, would you say it was a severe push or just a normal shove?
No, I wouldn't say it was a normal shove. It was definitely with some force.
With some force. All right, then. Would you agree that the push was what led to David going to the hospital? Would he have gone to the hospital if there was no push?
Objection, Your Honour. Leading the witness.
In the sense of, would he have gone to the hospital if the...
Asking...
I'm not sure if Sally is qualified to answer the question. Would you want to rephrase it? I mean,
Okay.
you were asking if it's...
I was asking in the sense of Sally is the mother of David, so they must have a relationship where he speaks with her.
we've established
And so,
that, yeah.
did she ever recognize if he had any headaches or any stomach aches that would have led him to go into the hospital at all, or any other?
Okay.
Yes.
But yeah, if you could just ask about the general health, perhaps.
Yeah, the general health.
So yeah.
All right, then.
You could still get to the same point in that.
All right then.
Thank
Could
you,
I ask about the general health of your son?
Yeah, he was fairly healthy, just like any normal sort of individual. He didn't have any health issues or anything like that.
Including that evening?
Yeah, even that evening was fine.
All right then. Thank you, Your Honour. That is the end of my questioning.
Thank you very much. Hello, Ms. Platt. Please could you explain to the court what time, if you recall, did you go to bed on the evening of the 21st of March 2021? Approximately, if you can remember.
I can't really remember. All I know it was in the evening sometime, maybe 9:30. Could be wrong.
Okay, thank you. And you mentioned that it was your birthday that day and you'd been celebrating.
Yeah.
Had you been drinking alcohol in this celebration?
I'd had a glass or two. Yeah.
A glass or two of
Just wine.
a couple of glasses of wine.
Yeah.
Thank you. So you mentioned that you were asleep in bed and you were awoken by raised voices outside. Could you hear what they were saying?
I wasn't asleep. I was getting ready for bed. And
Sorry, just to interrupt you. In your statement, it says that you were awoken when you heard some raised voices.
Apologies, if I could just, an updated statement was circulated, it just may not have...
Yes, I have the updated statement, which in which you state that you were awoken when you heard some raised voices outside of the house.
That is what I have. Is that the case?
No, I believe in my updated statement I did clarify that I wasn't actually sleeping at the time and I was getting ready for bed.
Okay.
Okay.
Yeah. But you were in the bedroom. You were the curtains were drawn. Can we just establish precisely? Did you see it from the very start?
I didn't see it, but because my bedroom is at the front of the house, my room does overlook sort of the driveway. And when I did look outside my window, I just happened to see when Phil had pushed David.
Okay.
Okay.
Thank
Sorry,
you.
Back to you. Yeah.
No, I
Thank you.
appreciate it. It might be difficult to remember some of the facts. So if you could just remember to the best of your ability, I appreciate that it was some time ago and you had a couple of drinks that evening, which might explain a few discrepancies between your statement. So when you heard the raised voices, what made you go to the window? What made you go to see what was happening?
Because it was loud. Obviously, it was night time. It was just something that I could hear, so I just approached the window to see what was going on.
Okay. And what did you see when you looked outside of the window?
So I saw Phil and David, and just as I got to the window, I saw Phil push David onto the ground with some force.
Right, just as you got to the window?
Yeah, when I got to the window.
Okay. And was Phil, if you can recall, facing towards you, or did Phil have his back to you when he pushed David?
He was facing towards me. I knew it was him.
So David had his back to you?
Yeah.
Okay. How clear was your view from your window?
It was quite clear. The curtains weren't drawn at that point. So, you know, I had a really good viewpoint, and I also remember Phil had a cricket bat in his hand.
Okay. And was Phil holding the bat when he pushed David?
Yes, he was.
Okay. Do you recall which hand he was holding it in?
No, I don't.
No problem. How did you know that David had hit his head?
Because I saw David fall down onto the ground and he wasn't moving. So then I quickly rushed outside and I approached him, and I could just tell he wasn't moving. He was unconscious at the time.
So he wasn't responsive. Was he breathing?
No, I don't believe he was.
Okay. So did you administer CPR?
I remember calling an ambulance really quickly, because obviously I was panicking at the time. They did come really quickly, and then I put him into a recovery position.
Okay. May I ask, are you first aid trained, Miss Platt?
No, I'm not.
You're not. Okay. Were you aware that in cases of serious head injury, moving the victim can cause further damage?
No, I wasn't.
So were you not advised when you called the paramedics over the phone? Usually they give some advice as to what to do whilst you're waiting for the ambulance.
Not that I can recall, no.
So you just took it upon yourself to just put him in the recovery position as a matter of precaution?
I could have been advised. I don't remember receiving that advice, but like I said, it all happened very quickly. My son was on the ground, and I was just worried about his safety.
I can imagine it would be very traumatic. In your witness statement, you say that David went to hospital and he was in hospital for 2 weeks. But then you go on to say that he was almost back to his normal self by the time that he was due to be discharged. Can you explain what you mean by back to his normal self?
So he'd recovered quite well. At the initial start when he was in hospital, his injuries were quite severe. And I remember I visited him every single day. But he was getting better. He had fully recovered, and he was actually due to be discharged before he died.
Oh, okay. And can you tell us what happened on the day of David's death?
It was the day that he was going to be discharged. I went to see him like I normally do, and I believe the roof of the hospital had collapsed, unfortunately, and David, it had hit David, and he died.
Yes. But prior to this, you and David were conversing, he was conscious, you were having a conversation about what to have for tea that evening, is that correct?
Yeah. He was coming home, so like I said, I wanted to make him his favourite, but he was fine.
So as you mentioned, you visited David in the hospital every day for 2 weeks. During this period, did you notice any signs or indication of any damage to the ceiling?
Not that I remember, no.
No. Or anything that might indicate what was about to happen?
No.
And did you foresee in any way the accident that was about to happen?
No.
No. Thank you very much. No further questions.
Thank you very much. Anything in re-examination, please? Okay, thank you. Yes, just clarify one thing, sorry, Miss Platt. It was your birthday on the day?
Yes, it was.
Correct. That's I just hadn't picked that. I hadn't noticed that. Did you put that into your witness statement?
No, I don't believe I did.
Okay. Okay, thank you very much. Yeah, okay. Thank you. Very well. Okay, so we will turn to the defence, Ms. Hurst, to call Mrs. Hurst. Sorry, to call your first witness, please.
Thank you very much. On behalf of the defence, I would like to call my first witness, Mr. Phil Mitchell.
Thank you very much, Phil Mitchell. You were already sworn in, and you have pled not guilty to the
Yes, I pleaded not guilty,
pleaded not guilty to the charges before you.
When we're going to talk about the hospital ceiling, I'm sorry, Mrs. Platt.
You could just take a seat,
sorry,
please,
but the
Mr.
ceiling
Mitchell.
fell down in the hospital, and I'm here for this.
I'm sure these questions will come up, Mr. Mitchell. You may sit down.
Not come up yet. We've been here long enough.
We are establishing what's happened so far. You can sit down and await questions and answer them appropriately. Thank you very much. Over to you.
Thank you
Hello, Miss
very
Hurst.
much. Hello, Mr. Mitchell. May I begin by asking you, what is your occupation?
Mechanic.
Thank
Car
you.
mechanic.
Thank you very much. And what was your relationship with the deceased, Mr. Platt?
We were neighbours. He was a young lad. Seemed all right.
Excellent. And how long had you known Mr. Platt?
8 years, I guess.
Yeah. And how would you describe your relationship during this time?
He was all right. I mean, I'm older than him. He was. Oh God, it's a bit difficult. All right, you know, he was just a young lad lived next door with his parents. We got on, said
Yeah.
hello.
Okay.
He liked cars, I like cars.
And how long after living next door to each other did problems begin to arise?
When he got that bloody car. If it wasn't for that car, we wouldn't be here now. Whatever happened to the hospital that Boris Johnson failed to build or develop or look after, and Theresa bloody May and David Cameron.
Thank you.
Anyway, well, I mean, really.
If you could just answer the question.
Okay, I'm sorry.
So-
I'm sorry.
You mentioned that the problems
Was the car?
began when Mr. Platt got his car, which I
Yeah.
believe was quite noisy. And
Well, he saw the exhaust off, so there was no muffling. It just rattled. Can't have been legal, but anyway.
And had you spoken to David about the issues his car was causing you?
Well, we dropped a few hints that he might want to stop revving the engine all the time and messing about with it. One day I went out, he's heard about it already, just said, look, you know, this has got to stop. You're keeping us awake at night, you're waking us up in the morning, you're obsessed with the bloody car. Leave it alone. Rev it when we're not here.
Yeah.
And
And-
I'll probably, you know, I was ready to give him a crack, to be honest.
But you didn't?
No, I don't go around hitting people.
No, of course not. So the incident that took place in 2019, where you got into a verbal altercation,
We argued.
yes.
Yeah.
What happened following that conversation? Did Mr. Platt take your concerns on board?
No.
No. So he continued causing issues with his car.
Yeah.
Okay.
He was a young lad. They don't think, do they? And they certainly don't listen.
No. Was there any violence during this conversation
In 2021?
in 2019?
Oh, no, nothing.
No. Why not?
So I'm not violent.
No, you're not.
And I don't think he was violent.
Thank you. How many children do you have, Mr. Mitchell?
3.
And what are their ages?
9, 7, oh God. 3.
Okay. In your witness statement, you said on the evening of the 21st of March 2021, you were properly in the land of Nod. Please, can you explain to the court what you mean by properly in the land of Nod?
I was fast asleep.
Okay. And you were awoken by Mr. Platt.
Yeah.
And was
Again.
this a regular occurrence?
Yes. Far too regular.
Yeah. And prior to the evening in question, roughly how much sleep would you say you were averaging per night?
Oh, I don't know. It just disturbed all the time.
All the time. And
Yeah,
how
well, disturbed until late on and then disturbing early on in the morning.
and how long had this been going on for?
Felt like forever. A couple of years, I guess. I
Right.
think it started in 19 and it obviously ended in March 2021.
And how did this make you feel?
Pissed off.
And what impact did this have on your day-to-day functioning?
Well, it made the missus miserable, and if she's miserable, we're all miserable.
Okay. And on the 21st of March 2021, when you were woken up, can you explain what happened after you were awoken?
Yeah, the missus went mad. She's just absolutely sick of it. I think she was having a bad day anyway. Just said, right, sort him out, and passed me a cricket bat. Well, I'm not sure what I was supposed to do with that, but I suppose I just took it with me to show him I meant business this time.
Yeah. And why didn't you use the bat on David?
Well, because I've just said to you earlier, I'm not violent.
You're not violent. Okay.
I wouldn't have selected the bat, but I was afraid that she'd use it on me if I didn't take it.
Okay. So you were afraid.
Well, not really afraid. She's not going to hit me with a cricket bat. It's
No.
a manner of speaking.
Okay.
I might be a mechanic, but I'm not stupid.
And when you went out and you were holding the bat, do you recall which hand you were holding the bat?
No.
No?
I don't play cricket, so whatever hand was at hand, I guess.
Okay. And you were holding it when you pushed David?
I don't know.
Okay.
I really don't know.
Okay. And at any point, did you foresee any injury occurring from the push?
Didn't give it any thought.
You didn't give it any thought. Okay. No further questions, Your Honour.
Okay, thank you. Yeah. Prosecution, would you like to cross-examine the witness? If you remain where you are for the prosecution's questions, please.
Yeah, sir.
Yes. Thank you, Your Honour. Mr. Phil Mitchell, have you ever confronted before? You have mentioned that you have not confronted Mr. David with a bat before. This must be the first time because you're not a violent man, yes?
Other than for saying things to him or mentioning it in passing. We had 2 incidents, call it what you will, one in 2019 and then the one in March last year.
Yes.
That's it.
But you did, what happened during the evening, so when you went out to meet him in 2021?
Well, I went out because he was at the car. I went out to him and just said, not effing this again. We've had enough. You're working the missus up. What are we going to do about it? How am I going to stop you?
Yes. So how come he ended on the floor? Because
I shoved him.
you shoved
The
him.
man was not listening.
You shoved him.
And I'm sorry, Mrs. Platt. I'm really sorry. But yeah, he was not listening.
Yes.
And we were at the end of our tether.
All right, thank you. What were your thoughts when you did shove him? Was there any reason? Did you want to show him that you were angry or annoyed or
I
agitated?
wanted him to know that he had to start listening.
You wanted him to know that? Okay. What was his health like before that when you went out?
No, I'm not his doctor. I'm his neighbour. He seemed pretty fit, healthy, young lad.
Yes. Okay.
I thought, to be honest, he was going to give me a good shove back.
Yes. So,
But he didn't. He fell over.
All right then. So after you shoved him, you mentioned in your witness statement
You're
that
going to mention the hospital ceiling falling in yet?
we will get there.
Yes, please answer the questions as they arise.
Okay.
Yes. You mentioned in your witness statement that you did not see him fall because it was dark. You did not see that he had
I
sustained
don't
an
think I
injury.
saw him fall as such. It was dark. I mean, there was a bit of light, I suppose, on from the street lights, and I think my porch light was on, but I don't think I'd seen that he'd fallen and knocked himself out. I think it's pretty much... I could see it stumble backwards. What I couldn't see is that he'd fallen down, prone, hit his head and, knocked out.
But you were able to see him clearly to push him and shove him.
Well, when somebody's standing in front of you there, yeah. When they've fallen backwards into a garden and there's very little light, no.
Okay. So what did you do after he was on the ground?
Well, his mum came out. She'd obviously seen something or heard something. She came running out. She'd seen that he was on the floor. She'd gone over to him, and then she said, he doesn't seem to be breathing. So shit, and you think, well, I wasn't expecting that. This day's not turning out as I expected it to. And to be honest, I wasn't sure then. I think, went into a bit of a panic. Ambulance was called. Police officers turned up. The lovely Doc Cotton, who I'd seen before, and I don't know really.
All right then.
The rest is history.
Yes. What was your conversation like with PC Cotton? What questions did she
When?
ask you when she came in 2021, the evening?
At the time, at the scene,
Yes.
I don't know, I think she just said what's gone on. I remember seeing you two before, what's happened, and I've sort of said, I've shoved him. And of course they arrested me because I pushed him over and he was lying on the ground unconscious. So, I just went, I have to go give a statement.
All right then. Thank you, Your Honour.
Okay.
So we've not got to the ceiling yet then?
We will.
Will we?
We will, yes.
Yeah, I look forward to that.
Yeah. But your evidence as to the ceiling would be...
Well, I just want to know when
fairly
people are going to
limited.
start talking about some common sense.
Okay. In that case, then, do you have anything in re-examination? Of
No
your
re-examination,
No.
no.
Okay, thank you. I think you best sit down. Thank you. Thank you. And your final witness, please, Ms. Hurst.
Thank you, Your Honour. On behalf of the defence, I would like to call the witness Eileen Beale.
Thank you. Take the stand and be sworn in, and confirm your name and address to our clerk, please.
If you could please confirm your name and address, please, for the court.
Eileen Beale, 24 Haven Avenue, Bradford, BD 713J.
Right, thank you. If you could repeat these words after me. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
that
that the evidence that I shall give
the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
You may be seated. Your witness.
Ms Beale, can I begin by asking you, what is your occupation?
I'm currently the head of Health and Safety and Security at Albert Street Hospital, and with my team we're responsible for the health and safety at the hospital.
Thank you. And could you just give me a little bit more information on what exactly your role entails?
Well, as I say, I'm in charge of the team that's responsible for the health and safety of the people in the hospital. Obviously, we're very busy during COVID times with sorting all that out and just checking, that the building's in the appropriate order for people who are working and using and visiting the hospital.
Of course, thank you. And what was your role prior to the accident that took place on the 4th of April? What was your role in determining the report and what happened on that day?
On the day of the
following the accident,
yes. Well, I wasn't working and I wasn't on the premises when the incident actually occurred, but obviously I was involved and in charge of producing a report as to what had happened with regards to the unfortunate accident that led to the very sad, demise of Mr. Platt. So I was responsible for putting together a report all about that.
Thank you. And how long have you been working in this role?
I've been there for 2 years, just coming up for 2 years, yes.
Okay. So the leak, according to your report, started in the 3rd floor offices. Please can you explain how often were the 3rd floor offices checked?
Right, yes. Well, the 3rd floor, that's where the admin offices for the hospital are, together with the toilets and bathroom facilities for the staff. And with COVID, the admin team were actually working from home. So just in order to check things and keep up to speed with everything, the premises, the offices were inspected every 2 weeks. And just to check things were all in order. And the offices are obviously directly above Ward 14, where Mr. Platt was an inpatient.
Okay, thank you. And how certain are you that the rota for checking the 3rd floor offices was followed to the letter, as you mentioned in your witness statement?
Well, obviously, my staff have to report and fill in the worksheets and timesheets. So yes, I'm quite satisfied that did occur, because obviously we had lots of duties to do around COVID, and this was part of the processes that we've had in place.
Okay, thank you. And for the benefit of the court, please could you explain the outcome of the construction experts' checks?
Right. Yes, well, obviously we had somebody come in to have a look and see exactly what had happened. As I say, the premises were checked every 14 days and nothing was apparent and nothing had been reported from the ward underneath. The expert indicated that apparently there was a very slow leak in the pipes, in the plumbing in the bathroom.
Your Honour, I would like to object. Is that not her say?
I believe it's
In
part of
terms
the
of
report that
the expert's
we're asking
witness.
about. It's not speculating as to the view. I think we're because you put this in your report, did you not?
Yes, the construction experts' report was within the report produced by Ms. Beale.
In that sense, I think we're only asking questions on what is contained within Ms. Beale's own report.
Statement.
So in that sense, this is acceptable.
Thank you.
Alright.
So you mentioned that according to the construction experts, the build-up of water was visually undetectable. Can you explain what you mean by visually undetectable?
Well, that obviously when the premises were being inspected on the regular 14-day basis, there was no indication of any leaks or water, and likewise there'd not been any reports from anything being visible or apparent from the ward below.
So, in your professional opinion as the head of health and safety at the hospital, was there any way that anybody could have foreseen the accident that occurred?
No. I think that's sometimes the problem with water and leaks. It's just you end up with a build-up and then something happens. And obviously we're trying to do our best to prevent and check things as much as we could.
Okay.
Yeah.
Thank you. And one final question, Mr. Beale. What was the cause of death as confirmed by the coroner in your report?
Yes, well, at the coroner's hearing, and the coroner confirmed that obviously there were no allegations of medical negligence, and that the cause of his death was injuries sustained by crushing from the unfortunate collapse of the ceiling and the falling of the sanitary ware onto Mr. Platt.
Thank you very much. No further questions, Joanna.
Thank you very much.
Yes.
Yes, the
Over to
prosecution
you,
would
Paul.
like to re-examine.
Thank you.
Yes. Ms. Bale, I would like to ask, when was the last check carried out during the victim's stay in the hospital?
Well, as I say, we were carrying out the checks every 14 days. And I believe they had been checked at least, 14 days before.
Before he was admitted into the hospital, or before he was...
Before the incident.
Before the incident.
Accident on the 4th of April.
When would you say, in the middle of his arrival, or the beginning of his arrival, of his 2 weeks stay?
I'm not sure, obviously. I don't know if I put that in my report. I'd maybe have to check the records as to exactly what days the inspections occurred, but as I say, they were every 14 days.
Yes.
So at a minimum, they would have been inspected 14 days before his unfortunate demise.
Yes. Ms. Bale, you did say that you are the head of health, safety and security at the Albert Street Hospital, and you have been in that position for 2 years.
I have.
Yes, so you must be aware that normally with a free fall of water leakage, there must be evidence at least between 2 hours, considering the humidity and the environment on the ceiling.
Well, as I say, I think as confirmed by the investigators and the construction experts, it was visually undetectable.
Yes.
From either below or in the actual offices.
Was that for the ceiling or any other place? The leakage itself?
Both in the ward, the ceiling, and the floor in the offices.
Yes. Yes, I understand that water in, without constant supply anyways, would probably have much longer time for appearances on the ceiling. But shouldn't there have been, as you said, you did a thorough check before then, shouldn't there have been other signs like the wood or the moss on the furniture due to the water?
Well, I think obviously, in the terms of construction of buildings, there's usually a gap between floors and ceilings, and things can fester there for a while before being visible, either in terms of a damp patch or a drip or anything.
Do you believe that if you had done another check after, and if the collapse was not on that day, you probably would have found evidences?
Yes,
If we could, sorry, let me just. You're asking around the checks and
Yes.
and the visible damage
Yes.
that was caused in that sense.
Yes.
If we could just avoid speculating as to what could have been seen if it was checked or what have you.
Yes.
So if you could rephrase the question in that way, to get to the point that you were hoping to get to.
Okay. So you mentioned that your checks were before the victim was admitted, or during the time that the victim was admitted?
well, they would have been every 14 days, yes, sort of before, during, and until
In
the
between.
offices were reoccupied, yeah.
All right then. Thank you.
Anything on re-examination?
No re-examination.
Okay, thank you. Could I just check? So we cannot establish the dates of the last check, just arising from the prosecution's questions.
Well, I haven't got that to hand. I haven't got.
Okay.
It may well be detailed in the.
And it wasn't you that carried out these checks?
No, it was part of
It was
the.
your team?
Yes, yes.
Okay, right. And you oversaw your team doing this, or just took in their reports and...
Well, I mean, as a
On
team, we
trust.
worked very hard to, we were obviously preoccupied with what was happening during COVID, which is what most of the staff were, concerned with. But no, those reports were undertaken, those inspections were undertaken, yeah.
Okay, fair enough. Thank you. You may return to your seat, or you are free to leave. Thank you. Very good, thank you. I'll turn to our prosecution to make your closing statement.
Your Honour, members of the jury, you have heard from the witness of today's case, and may I just remind you of the elements that we must consider. First, we must consider that the act was unlawful and dangerous. To unpack this phrase, we must first consider what is an act. An act, like we all know, is an action. Well, whether we were all taught action words, jumping, running, shouting, doing. And so generally, things of those sorry. Nevertheless, omissions are not considered in acts, just as in the case of law, but we must consider that was pushing an act. In my understanding, pushing is an act. It is very much as well as carrying out an action, just as eating or dancing or doing something else. We must also consider if this was an offense. Now, under one of the statutory offenses is the assault occasioning actual bodily harm, and this is covered. This covers battery and assault too. It considers the mens rea and the actus reus of both. Now, for battery, as the defendant or as the defense had tried to establish, Mr. Phil Mitchell's actions were not aggressive. They were not serious or severe pushes. They were not anything more dramatic than a normal shove. Nevertheless, the law still states that battery involves touching no matter what and however slight it may be. We must consider this in the case of Collins and Wilcock, 1984. We must also consider if his act was dangerous. Generally, you might ask yourself, are there any unlawful acts that are not dangerous? But there must be if the law does place this. Now, we must ask what makes or what constitutes a dangerous act. In the case of Crown versus Church, against Church, 1966, we see that acts are dangerous if there is an objective risk that harm could result from it. Maybe the defendant may not foresee or have appreciated that there was a risk or a general harm to arise, but we must look no further because in this case we did see that there was danger and it was dangerous. His shoving was dangerous to the victim and resulted to him falling, hitting his head on the curb, and the traumatic head injuries. Even if the defendant does not consider this risk to be dangerous, we must still ask ourselves, would we want ourselves to be pushed in the middle of the night with somebody who probably cannot see where the curb is? And we must consider the test, the reasonable person's test. We are all reasonable here, and we will all understand that even if a harm is not foreseen by one subjective person, we must consider generally. For mens rea, we must also consider the base offense. As discussed, this is from battery, and battery considers either intention or recklessness. Was Mr. Phil Mitchell's shove intentional or reckless? During when the witness was called to the stand, I did ask him, what were your thoughts? What were your reasons for shoving him? And he did explain to me that he did have reasons for shoving the victim. This entails that he thought of it and he wanted to show how annoyed he was about it. This shows that he was deliberate in his shove. It was not just reckless, it was not just an act of involuntary action, it was thought out and it was carried out. This was intentional. More so, we must turn now to the main point, which is causation, the cause of death. Did Mr. Phil's action cause the death of the victim? First, there must be a clear link to the defendant's act and the victim's death, and so both factual and legal causation must be shown. Factual causation deals with the but-for test. And in the question, I did ask most of the witnesses who came by, how was the health of the victim? So every witness that I did ask this question did say, and even the defendant himself, that the victim was happy. The victim was in a good health condition, and that the victim was doing okay. I asked the mother, and she said she knew of no medical or health ailments that he was suffering from. And so we must ask, but for the defendant sending the victim to that hospital, would he have been there at that moment, and would he have died when he did so and how he did so? This is not just a mere injury. It was not an injury that stayed or lasted for one day. He had to stay there for the 2 weeks. When questioning the head of the security, I did ask, when was the rota taken for the 2 weeks inspection? And she said sometime in between. So, and I did try to make speculations, but that is unnecessary anyways. But we must understand that if Mr. Braille was not there for those 2 weeks, and he did not sustain the injury the way he did, would he have been in that hospital, and would he have died at that time? More so, we must consider legal causation. There is no contention that there can be other causes to the victim's death. As you can see, there was the collapse of the ceiling, and other times you can see that maybe if we try to pinpoint every other thing that had happened during the victim's life, he must have gotten bruises, scrapes, scratches, and we cannot pinpoint each and every one who possibly must have contributed to him gaining the scrapes and pin it on them. However, this is not just merely about scrapes or bruises. If the ceiling had collapsed in the victim's own house, this would have been a different story. But this was in the hospital, and he was in the hospital only for the reason of the fact that the defendant put him there due to his shove. Moreover, we must also ask ourselves, was this a new intervening act that absorbed the defendant of the fact that the victim was only in the hospital for that long? So a new intervening act sometimes absorbs defendants of the liability if that act of the victim was not significant enough compared to the new intervening act. But we must ask ourselves, once again, as I have put forward before you, would he have been there for that long to give a lacuna of time for the water and for the flooding to have pulled down the ceiling? No, he would not have been. The victim, Mr. David Platt, was in good health condition before he had met the defendant that evening. And possibly, even if we're to consider other circumstances, the fact that he was not a violent man, the defendant was not a violent man, we do not need to consider whether his act was dangerous to the extent of being violent or not. We must also consider that anything or however slight his push was, did contribute in the long run, in the sense that the defendant was taken to that hospital at that moment, at that time. We must ask ourselves, when and how and in what way did the defendant die? The defense may try to sway you with the argument of the case of the Crown against Jordan and the fact that the injuries must have healed by the time. The fact that the defendant did not foresee these things, or they were not foreseeable or mitigating factors included. But we must also consider that even if the injuries had been healed, it may seem as though the reason for the death of the victim is solely due to the unfortunate event of the ceiling. However, we must consider what brought the victim to the hospital. We must consider this. The room he was in at the time of the flooding and the stay of 2 weeks to recuperate. Is the defendant not liable? Having heard all this, I hope that you will consider every element that has been brought, and you will consider if they have been satisfied or not, beyond reasonable doubt. And I hope that when you do, you will find that the defendant was guilty of the offense charged. Thank you, Your Honor.
Thank you very much.
Okay, Ms. Hurst, for your closing statement, please.
Thank you, Your Honour. Your Honour and members of the jury, you have now heard all of the evidence in this case, which I would now like to take the opportunity to remind you of. The defendant, Mr. Phil Mitchell, stands before you today accused of the common law offence of unlawful and dangerous act manslaughter. In order to establish liability and therefore convict on the grounds of this offence, the jury must be satisfied beyond all reasonable doubt that the following elements are present in full. If there is even the slightest doubt of any of these elements, then the jury is obliged to find the defendant not guilty. The jury must consider: did the defendant commit an unlawful act? Secondly, was the unlawful act dangerous? And finally, did the unlawful and dangerous act cause death? With regards to the unlawful act, it must be proven beyond all reasonable doubt the existence of both the actus reus and the mens rea of the unlawful act in question. In this case, the unlawful act being assault occasioning actual bodily harm, contrary to Section 47 of the Offences Against the Person Act 1861. In this case, there is no dispute against the actus reus of assault occasioning actual bodily harm. Where the dispute arises, however, is on the existence of the mens rea of either intention or recklessness. As you have heard in evidence, my client is not a violent man, and he did not intend to harm Mr. Platt. If he had, he would have used the cricket bat he had at his disposal. He had no intention of using this, however, or causing any harm to Mr. Platt. His wife handed him the cricket bat. He did not pick it up of his own volition, nor did he use it when he had the opportunity to do so. In order to establish recklessness, the jury must consider the Cunningham test of recklessness, which asks, did the defendant foresee a risk that his actions would cause a particular result? As it is a subjective test, it is based on the defendant's own foresight of the consequences of his actions. As per his testimony, on the night in question, my client was fast asleep in bed when he was awoken by Mr. Platt arriving home, waking up Mr. Mitchell, his wife, and his young children, who were screaming as a result of being awoken, which was a regular occurrence. In fact, my client had been a victim of antisocial behaviour from Mr. Platt for not just months, but years leading up to the night in question. As heard in Mr. Mitchell's testimony, he was seriously sleep deprived as a result of the antisocial noise caused by Mr. Platt and under a tremendous amount of stress at home. Chronic sleep deprivation is defined as curtailed sleep which persists for a period of 3 months or longer, the main effects of which include not only physical and cognitive impairment, but also mental health complications, and inadequate rest impairs the ability to think, to handle stress, and to moderate emotions. Therefore, it is my submission that the jury must take into account this vital context, which shows that the defendant was not of sound mind in order to reasonably foresee a risk caused by his actions. In addition to the presence of an unlawful act, the prosecution must establish that the unlawful act was indeed dangerous. The objective test of dangerousness was established in the case of Church in 1965, in which it was stated, the unlawful act must be such as all sober and reasonable people would inevitably recognise must subject the other person to the risk of some harm resulting. You heard in Ms. Platt's statement that she was some distance away at the time of the altercation, upstairs in her home, looking out of a window at a dark street below, having just woken up from sleep and after consuming approximately 2 glasses of wine. I put to the jury that this is far from a reliable vantage point to gauge the force of the push, and that without a credible eyewitness it is impossible to ascertain the force of the actual push, and whether or not a sober and reasonable bystander would anticipate any harm resulting from it. The fact is, we simply do not know, and therefore it would be impossible to satisfy this element of the offence beyond all reasonable doubt. And finally, the jury must be satisfied that the actions of the defendant directly caused the death of Mr. Platt. The principle of causation consists of 2 essential elements, which must both be satisfied. Firstly, factual causation asks, but for the defendant's actions, would the consequences have occurred? Establishing factual causation is not enough, however, as it is far too wide, and could also be argued that but for Mr. Platt's antisocial harassment of Mr. Mitchell and his family, the outcome would not have occurred. Or but for the doctor not discharging Mr. Platt a day or even an hour earlier, his death would not have occurred. Therefore, legal causation must also be established, in which case the prosecution must prove that the defendant's culpable act was an operative and substantial cause of death and that there was no new intervening act. A new intervening act will break the chain of causation if it is an overwhelming cause of death and an unforeseen occurrence, which is clearly the case here. Nobody could have foreseen the accident happened, even when following the health and safety checks to the letter, as per the official report produced by Ms. Beale. The leak was visually undetectable, and sadly it was clearly just a tragic accident. The prosecution would have you believe that the defendant's actions were the cause of Mr. Platt's death. However, this is simply not true. As you have heard in evidence, the doctors had cleared Mr. Platt to go home and expected him to make a full recovery from his injuries. You also heard in Miss Platt's testimony that her son was all but back to his normal self. And although the prosecution makes reference to case law, this case concerns medical negligence, which is a foreseeable risk when an individual requires medical treatment. However, it is irrelevant to this case. As heard in the testimony of both Ms. Beale and Ms. Platt, there was no medical negligence present, and Mr. Platt was fit to go home, having sufficiently recovered from his injuries. Therefore, I submit to you that his injuries were in no way an operative or substantial cause of death, and that the cause of Mr. Platt's death, as per the coroner's report, was quite simply injuries sustained by the crushing. I must now take this opportunity to once again remind the members of the jury that the prosecution must satisfy you so that you are sure of the defendant's guilt. Nothing less than sure will suffice. So, if you find yourself uncertain of any of the aforementioned requirements, when you consider the evidence you have heard today, then the only verdict you may reach is that of not guilty. That is the case for your defence, Your Honour.
Thank you very much. Okay, so we now turn to our jurors to determine this case. There are some key facts that need to be determined by the jury being the fact-finding part of this procedure. In this sense, we've heard lots of evidence, as to the very untimely death by sanitary wear of Mr. David Platt. Now, the case may seem peculiar. The two events may seem utterly unconnected, but the prosecution has brought this case perhaps to test the boundaries of what amounts to causation in a situation like this, or where causation lies in a situation like this. Because the fact remains that, Mr. David Platt was in hospital because Mr. Phil Mitchell put him there in the first place. In putting him there, he was pushed or shoved to the ground. We heard some evidence as to the force of that push. We heard some evidence that Mr. Phil Mitchell was there with the cricket bat. So make of that what you will in the jury in terms of determining the nature of the unlawful act. But the fact is that a push in itself is an unlawful act, which could be prosecuted either under Section 47 of the Offence Against the Person Act, or indeed under Section 39, whichever offence would be considered, could be considered for that unlawful act. There are some tests, as both counsel for the prosecution and the defence capably explained, in terms of establishing an unlawful and dangerous act manslaughter, otherwise known as a constructive manslaughter, for we are constructing it from another offence. In that way, we established the unlawful act, that act was criminal, that the act was dangerous, and that the act crucially caused the death. If you are satisfied with all four of those elements, then you should convict Mr. Phil Mitchell in that situation. Clearly, a major sticking point is whether or not the act caused the death. You have heard a number of phrases such as what is de minimis, or what is minimal, or what is substantive or operative causes. It is to the jury to determine whether or not you think that incident of the toilet falling on and killing David Platt, Mr. David Platt, should break that chain of causation. Right? The cause in that sense, or if we are establishing the cause being Mr. Phil Mitchell's push, with the sad result that Mr. David Platt stumbled, hit his head on the curb, and then sustained injuries from that. If that, that being the start of the incident that led to his death, you need to determine whether or not the toilet was a predictable or foreseeable event in the timeline of that death. So I shall leave it to the jury to go away and to consider its verdict in this case. We shall adjourn until we hear that verdict. Thank you very much.